Audio check. Right. Good afternoon. It's 1:30. Let's resume. Just before we get on to the matter of conditions and the obligation, let me just pick up on the costs matters that we just touched on before we closed. We were having to think about it over lunch. I am conscious, obviously, that there are a number, as I said beforehand, a number of Rule 6 parties who are either not here or are perhaps not fully represented here today. And I'm also conscious that some of the Rule 6 parties are, shall we say, more heavily professionally represented than others. So I do want to ensure that absolutely without inviting any applications for costs, I do want to be sure that they're all aware of the position. So what I'm going to ask the programme officer to do, it'll be Monday now, is to write to the Rule 6 parties, obviously copied to the appellant and to the council, so you know what's going on. Point out that we've now finished all the evidence. Simply refer, as a matter of fact, that there are cost claims coming in from the appellant and from the council. Stress that we're not inviting any further cost claims, and refer them to the guidance should they wish to do so. But then in terms of timing, I'm very anxious that we get the whole lot, if there is a lot, them all in together. So although I take the point made particularly by Mr. Humphreys that it could be done fairly speedily, I'm going to take it relatively steadily. So I will invite any cost claims, and we'll put this in the note so that again people can see it, any cost claims by the end of Friday next week, at the end of the inquiry on the 8th of, I think it's the 8th of October. Responses a week after that, which I think is the 15th of October, and should there be any final comments, Friday after that, which I think is the 22nd of October. And I'll get the programme officer to set all of those out in a note so that everybody can see it. Any thoughts on that?
So that sounds very sensible. Could you, I suspect it'll be sort of implicit, but could you make sure that when the programme officer sends out her email, that it's made clear that the cost applications that the council and the appellants are making are against each other, they're not against any Rule 6 parties? I wouldn't want any of them to be concerned, if I may put it like that.
That's a very good point, thank you.
Well, I assume that the council isn't, but probably.
Yeah.
That
is a good point, Mr. Humphreys.
People less experienced who might be concerned.
Yeah, absolutely. So, I mean, particularly from the airport's point of view, the cost claim is against the council, and yeah, I'll specifically mention that it's not against any of the Rule 6 parties. It's a good point. Okay, that was it from me on the matter of costs.
Right. Should we just, I think the way we're going to structure this is spend most of the time that we've got available to us by going through the section 106 and the UU. Mr. Humphreys, hopefully somebody, you or somebody else from your team, can just kind of walk us through the approach that's been taken and set out the sort of controversial clauses. We'll just have a chat about that. Just on the conditions, we don't want to spend, I think if we'd had more time, we might have spent a bit more on the conditions, but we have been through them several times before. But if anybody has anything pressing to raise on any of those conditions, then now is the opportunity. We have seen comments over the last 24 hours, I think from PCAA, and who's it from Ban as well, or Miss Sutherland as well. So we've seen some comments in response to that. So we'll and obviously be taking those into account. I think the only thing from the panel's point of view is by next Friday, we need a list of conditions. And what we have at the moment is, which is quite useful, is a table where we have most of the conditions there in their format that they are, and we can see that there are drafting issues that the airport have, so we can take those into account. Just one, I think there's only one area where what we have at the moment, which is condition 6, where we have 2 completely separate conditions. And obviously going into when the inquiry closes and when we write our decision, we're going to need, we don't want a list that's got an either or an or. Now, panels previously expressed some pretty firm views on condition 6, so we were a little surprised that when we clearly indicated our preference for the monitor and manage approach condition. I mean, I'll say it again, we can take that one out. We're given a pretty clear steer on that. We've heard submissions on it. So when we get to next Friday, if we can have the monitor and manage condition in and take out the NSC's draft condition, that would be helpful. I think all the other conditions are just disagreements about wording, and we can come to a view on that.
I'm sorry, so we're going to maintain our position on our condition. That's our position. We're not going to agree to a monitor and management condition. It's certainly not the one that's been drafted by BAO, which simply requires reports to be submitted and doesn't tie them to any sequence whatsoever.
Well, we tried to be helpful on that.
I appreciate that.
Yeah.
We unfortunately have to present a case that
we were trying to make our life a little bit simpler by having and everybody else's by having
I've tried to make your life as simple as I can all the way through, but there are times when I'm afraid there's a limit to how far I can assist.
Just one other thing on conditions. Sorry, I've lost it now, but there was also, I don't know if he's with us, but Mr. Renshaw had also put in comments on the conditions, which we can obviously pick up on.
Yes, I think on the conditions as well, and I think both parties here have probably slightly pushed back against what I know you would have preferred with condition 15, the night flying and the QC limit. We did look very hard at whether it was possible to shorten this. I think you expressed the view, which I perfectly understand, that, look, this is a very long, convoluted condition, and of course it is. That's because it involves a particular mechanism that seems to be set out. We're, as between ourselves, I think they're happy with that wording, and I know that does, it's not a simple condition, but I think it's not uncommon. I think London City Airport has a not dissimilar one. That doesn't make it right, but it's not uncommon to have it like that. So I'm sorry that we haven't been able to meet the expectation there.
Probably also just worth mentioning on conditions that the set of conditions that certainly I've been looking at is the set dated 28th of September. Yeah, just thought I'd mention that because there have been various versions coming around. I didn't want to end up looking at different ones.
Is there anything else on the conditions specifically people want to raise?
There are 2, I think, important points that we wanted to raise. There may be more, and Mr. Henderson will pick me up if I've got this wrong, but condition 11, which relates to the need for the airport to be fully coordinated. We've put in our note INQ 79, which explains our reasoning for that, and indeed we rely upon various statements made on behalf of BAL to support the need for this condition. The BAO proposal, as I understand it, is that they're seeking now a condition that they would just have to submit an application in order to get past the Grampian point. So all they would do is apply for slot allocate for a coordinated status, and then that would be enough for them to be able to implement the 12 MPPA permission. We don't think that that is remotely good enough, because as we've already seen, once an application is made, it can be withdrawn unilaterally. So all they have to do is apply and then withdraw, and their version of the condition would have been triggered. There's also, of course, the possibility that they apply and the Secretary of State refuses because they haven't reached the capacity level, for example, that means that slot allocation is justified. So there are good reasons, we say, to require the fully coordinated status to be established before we can take the 12 MPPA permission forward, because without it being fully coordinated, as BAO themselves have said in their application to the Secretary of State for fully coordinated status before, and indeed the Chief Executive has explained to the Consultative Committee, they need that status in order to be able to have the necessary controls in place to be able to deliver the noise control and all the other features of the noise control regime which is being proposed by way of mitigation in this case. So I just wanted to flag that particular point up. The other points I've got relate to the noise contour conditions where we differ quite significantly. I don't know if you want to deal with 11 first.
Shall we just pick up on that one, on 11 first?
Yes, our position on this is, as you know, during the night we are a coordinated airport because of the existing controls. Obviously, you need to remember that an airport, that the airlines only go to the airport under contractual arrangements. They can't just sort of rock up and start flying. They have to have a contractual agreements with us, which gives us a high degree of control over the number of slots, the number of airlines, and we're able to control that as any other airport. It is absolutely right to say that full coordination gives an airport additional control when it gets to a congested state in the way that's explained in that joint note that Mr. Taylor put in. We did apply because we were beginning to get close to the 10 MPPA limit, and therefore that's exactly the sort of control that we would have wanted. The reason we withdrew was not some sense of being capricious. It was pandemic hit. We suddenly weren't congested or approaching congestion, and so we withdrew the application. Our concern about the original drafting is that it says no development shall commence until the Secretary of State has designated the airport. Now, that would mean that we had to apply at or below 10 MPPA. It would be difficult in those circumstances for us to explain to the Secretary of State why we are congested, even if that was lifted to some higher figure. The control would be a matter for the Secretary of State as to whether the Secretary of State thought at that point we'd become congested. Now, we're more than happy, because it's clearly important, in the Council's case, to indicate and to give a commitment that we will apply for coordination. Things about, will we withdraw? Well, look, we could discuss that with the Council. We fully intend to become a coordinated airport. We just simply don't want something that says actually we have to stop everything while the Secretary of State makes a decision or decides that we're not yet congested. And that's the simple difference between us. This was, in a sense, on our part, an olive branch to try and bridge a gap. That was our position.
Anything else?
No, I think I get it, basically. On the one hand, the airport doesn't want to be tied to what the Secretary of State does, but on the other hand, the authority is concerned about the possibility of an application being made and then withdrawn or never decided. I think that's what we're just going to have to think about, but I don't think that the differences are particularly severe. There's an important wording difference as to how you work it, but nobody's saying it shouldn't be a fully coordinated airport. It's a matter of how you phrase.
Well, it's different, isn't it? We're saying it must be.
Yeah, absolutely.
That's the point.
Well, that's the
Yeah.
minor but important wording.
Yes.
Yeah.
I guess the key test is going to be, is a reasonable prospect that the airport can comply with its obligations, because that's the test, isn't it? Reasonable prospect. So if it's contractual arrangements, does that provide a reasonable prospect of the airport complying with those conditions? And that's what we'll have to address.
Yes.
It's not certainty, is it? It's reasonable prospect.
No, this is about enforceability, because one of the defences to breach of a condition is, well, we didn't have the power to be able to comply with it. And so what we've done is to point you to the statements that have been made by BAL's Chief Executive, by their own consultants in the application for slot allocation, where they explain the reasons why it is necessary to have slot allocation, a coordinated status, in order to be able to introduce these, to have these environmental controls. So all we're asking you to do is to hold Bristol Airport Limited to the reasoning and the statements that they've made in public. And we're getting a different version here now, which is interesting, but we're asking you to look at the statements that they've actually made when they applied to the Secretary of State for their slot allocation for the coordinated status, because we assume that they weren't deliberately trying to mislead the Secretary of State. So that's our position and why we're there. So it's not about reasonable prospect of compliance. This is about whether there is actually the legal ability for Bristol Airport Limited to enable them to have the control to deliver the noise contour cap and the various other elements in respect of periods where they don't have coordinated status at the moment.
Just going back to your concern, it was suggested that there could be some wording along the lines of the airport will be obliged to submit the application, and that's because after that the airport doesn't have control over the decision to. And then you said, well, that they could just put it in and withdraw it. Is that purely the basis of your objection to that form of wording?
No, there's also the possibility that they apply and the Secretary of State doesn't grant them the status. And my point here is that they have to have coordinated status before they can move to usage above 10 mppa, because we have to have the contour provisions and all the other noise conditions and everything else in place in order to protect the amenity of residents, and in order to introduce the basis of control that the ES is founded upon. So it's about ensuring that the legal mechanisms are in place to deliver the impacts as assessed in the ES. It's a fundamental aspect of what we say is necessary in terms of the control that the airport needs.
But the airport can't compel the Secretary of State, so that's not within their gift to comply with that part of the condition.
No, but you're entitled to impose a Grampian condition, where there's I think the phrase in the guidance is a realistic prospect of that Grampian being discharged within the lifetime of the permission. Now we already know, as Mr. Humphreys just explained, that the airport has already applied for fully coordinated status. So this is something that they're expecting to do imminently. I cross-examined on it, if you remember. So there's no difficulty about them making that application. They've already done the work explaining it. It's just about waiting for passenger levels to rise in order to do that, and you've got the evidence on that. So that isn't a difficulty, and we say the evidence is clear that there's a reasonable prospect that they'll apply, and they've applied it before, and they must have done so on the basis that they thought there was a realistic prospect that they would get fully coordinated status. So on that basis, the guidance test on granting conditions, we say, is complied with.
Do you know if there's any precedent for this sort of condition on other airports?
Interestingly, I haven't been able to find one, but that's because most of the airport, the big airport decisions they're already coordinated. We did look. We haven't been able to find one. But so this is unusual, I grant you, and Mr. Henderson and I have had to learn an awful lot about slot allocation law that we didn't know before. But that's where we get to, and I hope that that's helpful.
Yes, sir, not wishing to prolong this too long. I think your point about reasonable prospect does resonate and does have relevance here, because even without slot allocation coordination, you still have to ask yourself, look, just on our contractual arrangements, our ability to let new airlines in or allow them to have new slots, does that give us a reasonable prospect of controlling the number of aircraft moved through the airport to make sure that we remain below the contour, which is obviously driven by the total number of aircraft in the 16-hour day. The point, I think, about the imminent, and that we made an application, and so an application from us would be imminent, is actually quite interesting. Yes, we made an application in, I think, 2019, when our throughput was about 8.9 million against a cap of 10 million. In other words, just over 1 million difference, in order, by the time the Secretary of State considered it, that we would be closer to the 10 million cap. In other words, we would be becoming congested, which is the test. The condition requires us, says no development shall commence until. In other words, we would be below 10 million on the basis that planning permission had been granted, with a 12 million cap. And the reasonable prospect there does not apply. What prospect is it that the Secretary of State would coordinate the airport when we have over 2 million of spare capacity? We wouldn't even be near a congested airport. And the third point is this point about control. It's just outside our control. As I said, if the concern is that we will make an application and withdraw it the following week, I'm sure we can talk to the council outside this and try and find some way of reassuring them on that. If the Secretary of State refused, the Secretary of State would refuse on the basis that the Secretary of State did not consider we're a congested airport. We did not need slot allocation. And that sort of then answers the question. We would have presented the case on the basis that we're coming up against an MPPA cap and a contour cap, and that we want slot allocation on the basis that Mr. Taylor explains. If the Secretary of State says, no, actually, you don't in order to control this, well, that's the Secretary of State's decision.
Is it relevant that the existing permission doesn't have any such condition? And is there any evidence that that's caused a particular problem in practice in terms of complying with?
No, because the elements of the existing permission that control noise relate to, in large part, the elements of the year when there is slot coordination in place. Yeah, and yes, and
the 10 MPPA cap existed, has been operated perfectly effectively. This whole slot allocation thing is entirely new, and the airport's operated for years without having this problem.
and can I just say that 2 points in response. The point about the 12 MPPA and the Secretary of State won't be able to grant the coordinated status. Of course, the 12 MPPA permission won't have been implemented because of the Grampian nature of the condition. So the physical airport, which is what you have to assess the capacity constraint against, will be the 10 MPPA airport. The other point, of course, we will say that if you don't impose this condition, or you can't, because you're not satisfied it would be discharged within the lifetime, then it follows that you cannot reasonably impose any of the noise constraint conditions that are proposed because they're unenforceable. And we will say in that basis, without this condition, you have to refuse.
Anything else?
The other condition that I wanted to raise is the condition relating to the noise contours, where we've got differing conditions, and you'll see that the local planning authority, it's 13, and we've got two competing versions. There is actually I'm afraid I noticed a typographical error in the NSC version on the second line where it refers to 40 dB LAQ. That should be 45. 13. So that it refers to the area enclosed by the 51 dB LAQ, and that should be the 45. And you'll see it's obviously an error because we get to 45 later on. So what the council's condition seeks to do is to tie Bristol Airport Limited to the noise contours that have been produced in the environmental statement that are the basis for the impact assessment. And so all of these numbers are drawn from various tables in the ESA, and you haven't got those tables, but if you're really interested, I can give you the page numbers. The bowel condition is somewhat different in its format, and I think there are a number of really quite substantial difficulties with it. So what we see, if we go to, I had to turn the page on mine, I don't know if you have two on yours, but there's a reference to upon commencement of the development, the area enclosed by the 57 dB daytime contour shall not exceed 12.42 kilometres squared. Hopefully you've got that on yours. So the proposition is that from commencement of the 12 MPPA, the daytime noise contour is to be tied to the 57 dB contour, not exceeding 12.42 kilometres. Now that is the contour cap for the 10 MPPA scheme. That then runs and controls the development right until we get to 2030. And at 2030, the area enclosed by the 57 daytime contour shall not exceed 10.7. So what is being proposed here is that the noise elements of the airport are regulated by reference to the contour cap in the 10 MPPA scheme and not those identified in the environmental statement. In relation to a nighttime noise contour, this proposal has no nighttime noise contour until we get to 2030, where we get to the area enclosed by the 55 dB nighttime noise contour shall not exceed 6.8 kilometres squared from 2030. So up to that date, there is no noise contour cap at night. And then the other issue with these numbers is, of course, 57 dB is neither low, as identified by BAL, nor SOL for daytime. It's somewhere in the middle. And the nighttime noise contour is tied to their identification of SOL. So there are, we say that this proposal doesn't tie the development to what has been assessed, doesn't provide the control necessary to limit the exposure of the local population to what has been assessed, and indeed doesn't provide any noise contour protecting the population at night. There are one or two other more minor points I could make, but that's the thrust of it.
So, yes, let me try and explain this. Firstly, the reason the 10 mppa contour number is there, the reason for this is that on the, or a concern we understood from the council, that on the grant of the new planning permission, it in effect supersedes the existing planning permission, and that it would be said the existing contour cap that you had, that existed if no planning permission was granted, will be swept away. So what we have in effect tried to put in place is when you get to 10 mppa, you have the existing condition that was to apply at 10 mppa. When you get to 12 mppa, that you get the new contour. And although this says added in writing by 2030, I've discussed it with the others, but it does seem to me it might be more logical to say by 12 mppa. It's supposed to, that's the contour when you get to 12 mppa, and therefore, in effect, you have two positions. At the beginning of 10 mppa, there's the existing condition. When you get to 12 mppa, there's the second condition, and obviously, in order to get from there, wherever you are, to here, you'll have to decrease over time. So that was to put it in. That's why that was put in, to try and overcome this problem that there's actually no condition at all that's applicable. The reason about the 57 dB contour is in a sense something and nothing. The point about these contours is to control the amount of noise. For the amount of noise that there are, the number of aircraft, there are any number of contours. As I've given the analogy before, it's like a hill. You know, you've got smaller contours near the top, bigger contours. It's exactly the same hill. And therefore, whether here you control the 57 contour, or the 45 contour, or the 42 contour, it's the same contour. A reason for keeping it the same is it does allow you more easily to then compare one set of contours with another and one condition with another over time. We don't have, there was in the 10 mppa, no 54 contour, and therefore a difficulty of replicating. The point about, well, this is to in some way tie to lols and sols just doesn't make sense. The assessment on lols and sols is the assessment made on those noise. This is simply a way of controlling that set of contours to a particular size. But it's the same noise. You can control it here, or you can control it here, or you can control it somewhere else. You're just simply controlling it. So that's why 57 was chosen. In the noise contour there, the from 2030 is simply a typo, of course. It should say by 2030. It's not intended that only applies after that. It applies at that particular point. So, you know, I think really those are our points on that. Yeah, those are our points on that. We've chosen for the nighttime noise the 55 dB contour and the size of that rather than the 45 or the 40 contour. Again, it's exactly the same aircraft making exactly the same noise. You're just controlling it at a different level. You haven't, by controlling it down to 45, you haven't made it quieter, because it's the same aircraft making the same noise. It's the same size of hill.
So I think I took from that what they are intending is that the 10 MPPA contour should apply between the construction at the start of the development for the 12 MPPA scheme and right up until the point when 12 MPPA is reached. And at that point, these contours kick in. So it's the same point I made before applies. They're not being tied by these conditions to the assessment in the environmental statement. It allows it would allow, for example, in relation to the nighttime noise levels, to be effectively not have any contour at all until 12 MPPA. And what we know from the environmental statement, because we can see what the data is, because it's drawn from table 6A.14 on page 11 of CD 220.4, it's in the NSC condition on the left-hand side of the page. We've got contours of particular size identifying the contours that we use, which identify the scale of the impact that's been assessed. If you allow the BAL condition to come through, you allow impacts to arise that have not been the subject of assessment. For example, the Lowell contour could be far larger than has been assessed. But the serious issue, the really serious issue, is that they're essentially asking for a different noise regime than for the ability to cause different impacts than they've assessed in the environmental statement. And I go as far as to say the imposition of their condition would be unlawful.
So I just don't understand that. The numbers in there, the 10.7 kilometres square for 12 MPPA is the number in the environmental statement. I think the number for night is the same. I've just been reminded the reason why there wasn't an equivalent of the 10 MPPA contour for night was that there was no 10 MPPA contour for night, so that we can't put in a figure from the 10 MPPA position. As I say, it's sort of it's just a misunderstanding of this point about the contours. Having a lower dB value doesn't mean you're protecting to a lower level. It's just the contour. All those contours are equivalent. So, you know, the size of the contour here for 57 and the larger size of the contour here for, I don't know, 54, and the larger size of the contour here for something else is all exactly the same noise. It's just like, you know, you're driving down the motorway and you say, well, I'm going at X miles an hour or X, Y kilometers an hour. You're going exactly the same speed. You just measured it in a different way. And so I can absolutely assure you that the numbers we're putting in here, and this is our absolute intention, are the ones in the environmental statement. That's the whole point of this.
Mr. Morehouse, anything from your team on any of the conditions?
Yes, please, sir.
Yeah.
Just draw your attention to various points which you've had our submissions on yesterday, but more really want to just draw your attention to the issue over replacement land and the silver zone extension. The way condition 25 is drafted is that it doesn't actually contain a requirement to prevent the silver zone car park coming forward until the replacement land has proved to be functioning properly. At the moment, all it does is require a document to be submitted and approved prior to commencement of development. and it's absolutely crucial in relation to the objection or the statutory consultee response from Natural England that condition's in place, and also compliance with the habitat regs. So I had drafted something onto condition 6, which was in relation to phasing, which made it conditional. But if you're talking about getting rid of condition 6, then you need to make sure that that is placed within condition 25 to ensure that it can't come forward. That's my main point about that, so just wanted to draw your attention to that. We did submit in our document yesterday that we don't believe that the ATM movements should be a combined amount. They should be separated out because what you do is if you allow one full amount, then you allow blending of the air traffic movements between these two particular very separate type of air traffic movements, and so therefore you do need to distinguish between them because they create different effects on the local population. So we believe that they should be separated out. We provided conditions in that within our document that we submitted yesterday. We also, you'll recall in our last about noise conditions that we were do believe that you in order to make this development acceptable, that you do need to keep in place the condition that prevents blending of the winter and summer nighttime flights, and we do appreciate that obviously you can't just impose a condition on that, and so therefore we would suggest that you have to issue a split decision in relation to that, and we've submitted a note on that, so I just wanted to draw your attention to that again. And we obviously don't think that condition 39, which is the PD rights condition, goes far enough. It only relates from, I haven't seen the plan, but my understanding is that it doesn't relate to the whole of the Greenbelt area. And as you know, we've brought quite a lot of evidence into the way that the ability to have PD rights in the Greenbelt area has led to a lot of problems in the way that the airport has developed. And so therefore we think that the PD rights should be removed in the Greenbelt area, and we've set that out. And then also linked in with that is that we have suggested a new condition in relation to aircraft stands, that they should be limited to a certain number. That's A, to prevent it coming forward in the Greenbelt as well, but also because if new aircraft stands come forward, they create new noise effects, and those haven't been assessed in development at the moment. So therefore we suggest that either there's a new condition preventing those aircraft stands coming forward, which could therefore be varied in the future if the airport wants to do that, or that PD rights for aircraft stands are removed so that they can, an application needs to be made. So they're my points. Thank you.
Thank you, that's helpful.
Excuse me. Yeah, I've looked at the document you've sent in. I won't pretend that I've read that very complicated document against the other conditions, but certainly if that's the way that we go, as you were speaking, I was just checking that I'd found all those bits in your document, which I certainly have. Oh, incidentally, while speaking, by the way, conscious that there are going to be a number of people helping us out on this session who haven't actually formally spoken. Could you all make sure that you send your details into the programme officer? So I do know who you are, it's okay.
Right, is anybody else in the room or virtually that want to put their hand up? Because we will move on now unless there's any other condition issues. Yes, Ms Sutherland.
Good afternoon, sir. Very briefly, I did manage to put a submission in earlier on today, but having heard some of the discussion today, I would like to be able to put some further information in. So I appreciate conditions have sort of been moving over the last couple of hours, it seems. And I would like to address the inquiry, not address it, but pop in writing more in relation to my comments that I've already made.
you're going to make any further comments, Ms Sutherland, you're going to have to do that by close of play on Monday.
Thank you, Sarah.
Yeah.
Appreciate it.
Thank you. Got another hand up, have we? Oh, Mr Renshaw.
Yes, thank you, Mr. Young. I did submit an amendment or amendments to condition 6 yesterday. I'm not sure whether you will have seen that note.
Yes.
You have. And I'm sorry, I missed any discussion on condition 6 just now, being slightly out of sync with the timings today. And the purpose was that Balfour understands that the appellant hasn't ruled out all reasonable alternatives to extending parking in the Greenbelt, and in line with our submission, we consider that the staff parking location is a significant omission in the very special circumstances case, and so our wording, additional wordings are designed to address that omission so that Greenbelt parking could only come forward if the staff parking has been moved or a report demonstrated that that's not feasible.
Thank you, Mr Renshaw.
Yeah, this is, excuse me, this is the bit in red in your comments, I think.
Indeed it is, although in relation to the North Somerset Council version of condition 6, we have slightly reframed the whole thing, but the bits in black are as worded by North Somerset Council.
Thank you. Right, shall we move on then just to discuss the planning obligations? Mr Humphreys, you want to take us through where we've got to? Just a broad overview, don't you?
Yes. So as you'll have seen, the version of the Section 106 agreement that was circulated, just to confirm, certainly the one I'm looking at is the one that has last updated 28th September 2021 on the front cover, and I have one that has a number of then comments from parties, and I assume that's the one that people are working from. So I think just by way of complete overview on this, what has happened over really relatively recent times, last few days and a bit more, is that some of the controversial, if I can put it like that, provisions in what you will have seen in previous versions of the Section 106 agreement have been removed. And the reason that BAL has done that is that that allows those to go into a unilateral undertaking and leaves what I think both parties believe in what you now have as the agreement, a set of provisions that we will be able to agree. Now, I won't re-go over the argument because I don't think there's a lot of point in doing so, but there was a proposal from the council that we have a sort of and/or version and that you could blue line it. Our judgment on that was that it made it extremely difficult to follow, and for people perhaps not involved in it and coming along later, it would just make, it would cause or have the ability to cause disagreement, and we think that this is better. So the consequence of that is that what you have as the Section 106 agreement is, we think, pretty much there. My understanding is that it is thought that it will be possible to finalise that over the next 2 or 3 days. You will have seen that there are a few provisions in there where there are sideline comments from parties, and I'm happy to take you to any of those that you might want to highlight or discuss, but I don't think, I'm sort of looking at Mr. Henderson and Mr. Taylor in particular here, I don't think it's thought that any of those would cause us not to be able to reach agreement. I think for the most part, it's a question of drafting. I may come obviously to some of them. I think certainly our expectation, and I suppose I'm saying this both about the Section 106 agreement and the unilateral undertaking, is that you should be able to see final drafts next week, early next week would be the ambition. I have to say, I think because there are now, unfortunately, several signatories, as you will see from the front of the Section 106 agreement, that we will probably need to ask you for the ability to defer signing. So you would get the final document, you would know this, we would be given, I think, 21 days or something to make sure that the originals were literally biked around to all the people and signed. I mean, we could discuss what period for that, but I don't think that need be controversial. I don't know, as I say, I'm very happy to take you broadly through the agreement in a minute. I don't know whether maybe Mr. Henderson, who I know has been very much involved in this, will speak. I don't know whether he wants to say anything first about my high-level point that we think this is an agreement that is, pretty much there.
But perhaps just before Mr. Henderson comes in, if I could pick up on a couple of things. There was a very useful email which I think must have come from Bowell, effectively identifying the problems with the blue pencil clause approach and the reasons why it's been split out. Quite honestly, I think that makes complete sense. I can well understand that if you tried to do a document with blue pencil clauses in, which cross-refer throughout the document, it could be a problem. So I think we're quite content with the approach. I mean, I've certainly turned on to Mr. Henderson in a moment. I've gone through the bilateral, the 106, and I mean, it does seem to me, I'm just looking at it now, there are a lot of comments in there, such as they are. It would be more appropriate to include this as a recital, sort of textual matters, yes, rather than fundamental matters. Now, when we come on to the unilateral, there may well be rather more significant matters, but unless my colleagues have, I realise it's only still a working draft. I'm quite content with it. There are a few definitional points and what have you, but I don't think there's very much. Mr. Henderson.
Yeah, I'm going to deal with the approach that's been adopted. The Council is extremely disappointed that Bristol Airport Limited has chosen to remove from the table before you the Council's preferred approach to the issues where there is disagreement by adopting the approach they've done. You can't make a choice now between what the Council said was necessary and what they say is necessary. Of course, the consequence of that is that if you aren't content with the mitigation offered in the unilateral, then there may well be ramifications as to whether or not you wish to grant planning permission. But we need to note that the choice that we were seeking to give you is no longer with you. And I saw the different clauses, and certainly my view was that it was no more difficult to deal with the blue pencil approach than is normally the case. But there we are where we are. And in terms of the substance of the Section 106, I'm going to hand over to Mr. Henderson.
And in that regard, so Mr Humphrey's summary was very fair. So this is something that can be and will be agreed in pretty short order. I think it's fair to say all of the ingredients are there. We know what all of the big ticket items are. They're pretty much agreed. We're simply dealing with the mechanics of quite how that's going to be recorded. There's a couple of points which we'll need a further discussion on, but subject to that is essentially a question of the solicitors, the lawyers, I might say, so finishing the job, getting all of the terminology in a way that works, and then we're there, certainly on the 106.
And so you mentioned the point about certain things being moved to a recital, and we can see an example of that on page 6. I don't think we have a problem with that at all. This was a point about an understanding of which conditions on the previous permission had been discharged, and you know, I think between the council and ourselves, we ought to be able to work this out and set this out. I don't know whether there are either, so in your case, particular of the boxes you want to just talk through, or indeed Mr Henderson, you know, we can always perhaps...
Yeah, not from our perspective, sir, unless it's going to assist you. We've had a discussion yesterday. There's been further correspondence late last night, early this morning. Matters are moving on pretty quickly, and as I say, we will get there, certainly on the 106. We will get there.
Yeah, I mean, I certainly didn't have anything, excuse me, I didn't have anything highlighted on this document. I suppose it's, just picking up on Mr Taylor's point, I understand what you're saying, I understand the position, but we can only effectively deal with what we've got.
That's why I said the LOE.
Yeah. Okay.
Okay. So I'll put that one to one side, and I'm very grateful to Mr Henderson. I know he and others on his side, and people beside and behind me, and others on our side have been working very hard on all of this. I haven't. I've been at my leisure in here, sir, doing almost nothing. But I know that others have done lots. So I'm grateful to all of them. So on the unilateral undertaking, there are obviously, and again, I'm very grateful.
Sorry to interrupt, Mr Humphreys. Can I just double check we're looking at the same document?
Yes, sir. I've got a version that has on the front cover quite small writing with NSC comments 29th of September.
That's the one that I've got. Yeah.
Thank you. 29.
29.
Okay, that's not the version I've got, but it's fine. I know which version it is. I'll find that version.
Do you want to get hold of a copy?
Because I've got the 30th of September, but it's fine. Don't worry, it's fine.
Well, we'll just wait for you to be handed over.
Yeah, I don't think we have the 30th. But
No, I don't think you do. We have been working very hard.
Yeah.
It's through a number of iterations.
I very definitely asked for the version that you had.
Yeah, very wisely.
There are obviously, because this has happened relatively recently, provisions have been taken out and dropped into a UU. I'm very grateful to the Council for the comments it's made on the document. And although it's unilateral, it is obviously our ambition to try to resolve issues where we can. There are some fundamental things that it won't be possible.
Actually, that reminds me, sorry to interrupt again, Mr Humphreys. I appreciate that, albeit it's a unilateral, that the parties are working together, but my assumption from, excuse me, from looking at a number of the notes is that there isn't going to be an agreement on a number of the points, I guess.
Yes.
And it does seem, so we can set the bilateral aside, because the assumption is, well, it's going to be signed by both parties, so it will be agreed, obviously, by definition. But on this one, I think as well as the draft and then the final version, I think we do need some information as to where the remaining differences lie. Now, I mean, they're set out in note form in this document that I'm just about to look at, but I think for our purposes, we need something to say, right, well, here is the unilateral. We, the authorities, still have issues with clauses X, Y, and Z.
So that's very fair and entirely correct. We've discussed that already between us. Our hope is that, for example, if we were to have a final draft from BAL by close on Monday, we would then be able to put that together for you so it accompanies our closing submissions. And you could then have the final draft, our comments, and it would be over to you at that point.
Okay, thank you. Mr. Humphreys, yes, I interrupted.
No, not at all, sir. So that there are certain issues clearly that are, if I can put it like this, sort of legal technical, because this document has been created, it's unilateral, not bilateral for lawyers, that has certain implications, and the Womble Bond Dickinson team and others are working through that to make sure some of those things. The council's very helpfully made comments on that. I'm not going to touch on those things. I'm going to try and go to the slightly more fundamental points. There are a number of definitions and things of that sort, and those are being worked on, and I may need to come back to some of those, but I think the real meat of the issues...
Sorry, I'm going to interrupt again.
No, of course not.
I'm just skimming through my version. On the definitions, and I'm looking particularly at the comments from the council, 90% of which I understand. On the definitions, the 10 MPPA trigger date, comment from the council about the retrospective nature will need to be reconsidered.
Yeah, so
I didn't follow that.
So let me explain what the concern is. The trigger for the bus provision, which is at the heart of how you increase public transport here, is based on that 10 MPPA trigger date. Now, the difficulty we have is that 10 MPPA trigger date is a reported date. So you finish your year, you clear your 10 million, and then you get your report. And you, of course, have seen the condition which deals with that. Now, our concern around that was that on a worst case on our version of the condition, you could do 10.1 in January. So you cleared your 10 million. You get to December, you get 3 months, and then you're into March. And then, for the purposes of the UU, your bus provision then kicks in. On the appellant's case, the condition is slightly different. You would get to December, then you get 6 months, so we get to June, July, and then it kicks in. We talked about this yesterday. There is perhaps one very technical and complicated way we could change it. It would require different reporting in the very short period before you get to 10 million. We've simply taken a pragmatic view on that yesterday, and we said, look, the worst case on our assumption, it's a 15-month delay. We will live with that because it's at the very start of the period beyond 10 million. It's not ideal. We'd want the buses to come in as early as possible for all the reasons that you've heard in the evidence. But we will live with that, and so that definition will stay the same as a result. I hope that's clear.
Thanks, yeah. Yes, carry on through, Mr. Humphreys, and I'll doubtless butt in again.
Now you see why I'm not doing it, Mr. Humphreys.
So you're the inspector, you can butt in any time you like, frankly.
Oh, I will.
I'm really grateful for Mr. Henderson, who, you know, as you'll have gathered, is obviously closer to a number of these things than I am. So I was going to take you to the schedules. I think most of the comments before that are reasonably self-explanatory, but it's really the schedules. Now, in Schedule 1, this is the obligations relating to transport and travel, and we start with a number of definitions, and one of the, I think, principal things here that we're all trying to grapple with is translating the intention, I think, of the parties in terms of the public transport mode share target into a form of legal text. And there are several different issues in play here. There's obviously a fundamental issue, which is why this was moved to the UU, and that on page 11 here, and 233 is the difference between the two 233A, the difference between the two parties, between our proposal of a 2.5% increase in public transport mode share and all of the things that flow from that, 0.5% annual increases, and the council's position on that. And I think both parties have agreed that that's a gap that they're not going to bridge. So I identify that and leave that to one side. I think there's another issue that we are working on, and this arises from the situation where, as you will recall from the highways topic, currently the public transport percentage is calculated by reference to this bus data. What we know from looking for the same years at the CAA data, which is a collection obviously from bus tickets, but by interviews, asking people how they've arrived, is that there's a disparity between the two. There's an intention on the behalf of both parties that moving forward we should move to the CAA basis. There's a challenge for us in what, for shorthand, Mr. Henderson will probably tell me I've not got it quite right, but there's a challenge in terms of what I will call rebasing. In other words, how there has to come a point where you say that this percentage in bus is equivalent to X percentage in CAA data, and then having rebased, you then apply your percentage and move forward into the future, and the bus data ceases to be important in the way that it might be at the moment. I mean, it can be available, but it's not important. I think there's been some discussion, and Mr. Henderson may help, and we certainly had an interesting email from someone, it wasn't to me, someone within the council's team this morning, suggesting that for the mechanism for rebasing, so how you do that, that in effect we have a mechanism whereby that is not decided here. There is a process by which it is decided. We have to put forward a proposal, and I think the council would then consider that. That, it seems to me, may be, unless we can come up with a methodology, may be an appropriate solution. Our thinking on that, because this provision is in the, and I'm sort of half saying this across to Mr. Henderson to see what he thinks of it, because this provision is in the UU, which doesn't obviously have a dispute resolution clause in the same way, is that if we defined the rebasing methodology, we had a definition for rebasing methodology, we say in Schedule 1 that the rebasing has to be in accordance with the methodology, the definition then simply cross-refers to the Section 106 agreement, which does have a dispute resolution thing, and in the Section 106 agreement there would be a standalone definition that says, look, the rebasing methodology is to be, there will be a submission to the council, and the council will agree it. If there is then not agreement on that within whatever the time period is, we would go through the dispute resolution. It seems to me that that may be a way forward, but I'd be really interested to hear what Mr. Henderson
take
thinks.
those all in reverse order. So yes, that would in principle work for us. So the important thing, as Mr. Humphreys explained, is about setting the right baseline, because that baseline must reflect what was in the 10 MPPA Section 106, and it's from that baseline that we apply the uplift. And you can see that, for example, in 2.3.3, which Mr. Humphreys referred to, subparagraph A, a stretch target increase to the PTMS of 2.5 above the 10 MPPA consented baseline as rebaselined and measured under the new methodology. And then if you just follow that through, you'll see the words struck out, because of course we've moved it from the 106, approved by the council. So it's how do we deal with those words that have been struck out? And we are in agreement that in principle, deal with the baseline in the 106 and then deal with the uplift.
And then the two effectively relate to each other.
Correct,
Yes.
and that would work because you will have an executed 106 at the same time as you have your executed UU, and so you will know this is a working mechanism because the two will merge. So that was the last point. Just on the bus ticket data, it is correct to say that it's about translating the bus ticket data into the CAA, because that's the all-important starting point, and of course you've heard my cross-examination about whether that's been done correctly or not to date, but that is the all-important starting point. The only thing I'd add to that, which it goes back to 1.1 on the previous page and the definition, I think we're almost there, is that we see the bus ticket data actually has two roles. It has the initial role, which you've got to re-baseline to get to the CAA data, but it actually has an important ongoing role for the purposes of planning and monitoring services. So we need to know how many people are getting on different buses and how that works so that it can plan through. But we're pretty much there, I think, on an agreement. We need to reflect that in some updated wording. But just so you're clear, when we talk about the bus ticket data, that's how it works.
So that's
I'm not clear on why you need to move away from bus ticket data and move on to this. What's the flaw in using the bus ticket data? Because that's
I think, sir, the concern with this is that it's not accurately reflecting the public transport mode share. And if you remember in Mr. Witchell's evidence, he had a list of a number of reasons why he believed this was likely to be the case. Because if the discrepancy between the bus ticket data and the CAA data was small, you would say, well, look, this is, it depends who you ask and everything else. But it is quite noticeable. And the thinking is that either some people are buying, for example, they come by rail, they transfer to bus, but their rail ticket is a through ticket, so there's no separate bus ticket.
right.
Or they come as part of a group, and so they all sort of arrive as part of a group. There are no separate bus tickets in that way. And I can't remember the paragraph in Mr. Witchell's evidence, but
it's there, isn't
but
it?
yes, it's definitely there. And I think, in fairness, I think both the council and we think the CAA data is better, and that's also what all the other airports use. I think if I can just go back to Mr. Henderson on his point in paragraph 1.1 and the definition and the red text there in the middle of that page 10. I think, Mr. Henderson, we're happy to go along with this. I mean, we have to have it with those words in parentheses, subject to permission of the bus operators, because the bus ticket data is not our data, and bus ticket operators may regard that as commercially confidential because they're in competition. But subject to that, we're happy to share it. And in a sense, I suppose, maybe that any that don't want to give it to us may be willing to give it to the local council anyway. But certainly from what we've got, I think we would be happy with that.
Yeah, I had understood that in principle that was agreeable. I think we need to have a slightly more detailed discussion separately about how that's presented. But,
Sure.
But let's not deal with that right now.
And so in relation to this document, so I've touched on those points in part 1 of Schedule 1 on page 10. I picked up this point about the new methodology on page 11, which is in part 2. On page 12, there's a matter there that has attracted a few comments in paragraph 2.3.5, which I think may occur in more than one place, but there's in 2.3.5a Roman 1, there's some words subject to patronage and viability, and the issue here that I think we're trying to capture, and I think the council understands, but just wants to make sure we've got the language right, is that clearly we're going to be providing money to support bus services. If after a period it becomes apparent that, look, this bus service, you know, we're pumping a lot of money in and people just aren't using that one, then we need the ability to pump it into another service. We don't want to be stuck just pouring money into something that's obviously there isn't a demand. Now, the words subject to patronage and viability were put in there to try and reflect this. I'm sure you know, we can discuss it. I mean, that was, I think, some wording that was there before. I don't think on this that there's a fundamental difference between the parties. It's just a question of kind of capturing the right language, I think.
Yes, I mean, I've just written the word vague in the margin.
Precisely,
Yes,
sir. Yeah,
I think it's already there as
I'm,
well.
I'm very simple with these things.
No, so you're very much on the mark here. Of course, patronage and viability, they are relevant, and having regard to them in the way that Mr Humphreys has outlined is not something that we are in principle against, of course. But when we are dealing with a UU, which we need to enforce without a scheme that's been agreed and worked through, we need a level of precision that allows that to be done effectively. And in the way that you just described, we say that that's too vague at present for that level of precision to be there. You put yourself in our shoes, we say on a Roman numeral 1, subject to patronage and viability, and we go, why have you stopped the service? And they say patronage and viability, and we go, it's impossible for us to enforce at that stage. So yes, relevant, yes, can be considered, but it has to be in a way which allows enforcement and isn't vague.
Yes, I was just trying to check, you know, the sort of where this had come from, and I think this is this in the existing. Yeah, so it's actually in the existing section 106, and it's been in all the previous ones. I think, sir, you know, whatever view one takes about the vagueness or otherwise of these words, I think what it probably is important to bear in mind, it's in this same schedule that has the 2.5% target and then the series of key performance indicators. So we will clearly have to be hitting the key performance indicators to achieve the 0.5% improvement in public transport use per annum anyway. And if we're not doing that, we're going to have to, you know, look at other measures in order to hit that. And it seems to me that that is, you know, that's the in a sense, the, you know, the operative part of this, which is important. This provision is much more to do with, look, what are some of the things that are going to be brought forward to meet that. And if we don't have some wording of this sort, it's very difficult to think how do we come up with a scheme on which we decide whether, you know, a particular service is being sufficiently successful or not. And therefore, you know, it seems to me there is perhaps some reassurance for the council in the point with the KPIs, and you can see, you know, in the clause above 2, 3, 4, you know, all the points about, you know, if in the first year you don't meet a KPI, you know, this happens, and then if you don't meet it again, you know, that happens. In a sense, it's those things that are driving the public transport mode share improvement. This is, in a sense, much more to do with, look, what do we think are going to be the services that actually bring that about. Having said that, you know, I mean, obviously, if Mr. Henderson has I mean, and I mean this genuinely, sort of thoughts about wording, then, you know, I'm very happy to you know, talk with the clients about it. But I think we both know what we're trying to do. It's not a fundamental dispute.
When you say that the wording ties back to the 10 MPPA agreement and the draft 106, was there any sort of scheme to be submitted element in there? Whereas now, of course, we don't have that in a unilateral, or was it exactly the same wording?
I think it
Fairly
was the
sure
same.
there was an approval mechanism. It's being checked, but I think there may have been. And that obviously gives rise to the difficulty, as you said.
Yeah.
But we'll check that. If you want the answer now, we'll do it straight away. But
No. I think I can understand the concerns, but it is a matter of tying those words down in some way.
Yes, sir. And I take the point about the KPIs. You'll see that only one of the KPIs is defined. So there's a set of KPIs that we're dealing with. Yes, I follow the train of thought, but it doesn't get us there all the way. So we're happy to work on it if we can, but
Surely.
I hope it's clear where we are.
Now, so going on through the agreement, that there are a number of comments on, for example, section 3, which is to do with the new public transport service, and I just need to check where we have got on that, because that may be one where things have moved on. Yes, I think in clause 3.1, the difference on funding here is whether this is tied to the Public Transport Improvement Fund, and we think that should be, and that you know, there are obviously mechanisms around the calculation of that that fund. I think the council's position is slightly different, but it may be that Mr. Henderson will want to explain that.
It is, so you've got a fairly lengthy comment actually on the side, which gives you a flavour of where we are. So yes, PTIF can deal with the pilot period, but not the permanent provision, and you've got some reason below that. And indeed, yesterday, I think the 30th, what day are we are today? Yes, yesterday, there was a further email back to BAL with some further explanation on that point, so they understand what the issue is, going through the detail of the costs. But I mean, it speaks for itself what the comment is there, and if there's some movement on that, then great, and if not, we'll have to make our submissions about whether that's adequate.
That was the sort of comment that I had in mind, where I was saying, well, if you can't agree, that's the sort of thing that we need to see.
Exactly, sir, and if we need to
Yes.
set out the rationale, we've obviously shared it, we can share it with you in due course, and you'll make a judgment. But hopefully that, at least for today's purposes, gives you a flavour.
And so, obviously, sir, on that, you know, I'm sure the parties will, you know, continue to discuss things, but I suspect this may be one of those areas where you get two comments, I'm afraid. Scheduled, just check whether there's anything else on that one.
There's nothing further on that issue of the bus services from us, so we have explained it.
So, Schedule 2, relates to the noise mitigation scheme, and I think, although there are a huge number of comments here, I think one of the principal issues between the parties seem to be the point in the definition of noise mitigation fund, which talks to the fund being up to a certain value. I think here, sir, the previous noise mitigation fund also had a limit. I think it was about 100,000 per annum, and my understanding is that was never exceeded. I think the intention, sir, of putting, paradoxically, of putting the 200,000 in here was to give confidence. It was to show, look, you know, we are making provision now for something per annum, which is double what was available before, particularly because take-up, so obviously reflects the fact that a very large proportion of the homes are already insulated, although obviously those eligible will reflect the size of the contours. It's not as though you suddenly get to, you know, much larger contour overnight. You know, it's not as though we'll be at 12 million next year with a very large contour, and that therefore that kind of cap was perfectly appropriate. It was not thought it was going to actually constrain the size of the fund, but it does just allow the airport to, you know, budget appropriately in its costs and make sure it's made provision. Having said that, if this is something that you know, that really is very important to the council, and that seems to be what is being said, then I'm told we can take that out. As I said, the idea was to demonstrate that a lot more money was available in this fund than in the existing fund.
Yeah, we heard quite a bit. We've heard quite a lot of evidence on this, haven't we? As to, you know, if X number of people apply to the fund, how long would it take for all the work to be done? If one were to take it out, where does that leave you? With the BAL would then have an unrestricted obligation to provide funding for the noise mitigation scheme.
We don't anticipate, because obviously people have to be eligible under the scheme.
Yeah, when I say unrestricted, I was
And
assuming eligibility.
because most, you know, the schemes have run for years, and you know, obviously we're here around you know, an international airport, and homes will have insulation for the most part, and have had availability to draw down funds from the previous schemes. Obviously, you know, as the airport changes and it grows, we recognise that there may be some people that haven't taken up the availability of the scheme before, and there could be new people that fall within some of the areas, and that's entirely proper and recognised, and that's what we anticipate the scheme will be for. We don't anticipate, I have to say, that the actual take-up would be above 200,000. That would be pretty surprising. And therefore, as I say, I was talking to people within the airport who were slightly surprised, because they thought they were actually showing, look, we're going to make provision each year for this much to be available. But I can see it's you know, from things that were said yesterday, that this has obviously caused unintentionally some disquiet within the council, and as I say, you know, it does help us to, you know, for any corporate entity to be able to say, right, we've got a maximum of this liability, you know, every year, and fund for that. But we don't really want to have a major fallout with the council over this.
May I contribute at some point? It's Mr. Morehouse at the back.
Oh, sorry, Mr. Morehouse.
This is a very interesting area because you've heard evidence called by the PCAA on this subject matter. The reality for people is that the way that the scheme is advanced and the amounts of money and the caps to individual claims that are put forward are such that most people that certainly, and when we called one witness to talk to the inadequacy of the structure of the scheme and the caps that are put on the scheme. And if I may make some observations, because of course the reason for this scheme is because of legal restrictions on nuisance claims for civil aviation. And the courts are full of equivalent cases for example, military airports, where significant financial awards are made to people for things like depreciation of value in houses, for the ongoing nuisance features of the aviation activities, military aviation activities in the area. This scheme that is being put forward falls significantly below, and what has been advanced in the past falls significantly below anything that is dealt with under those nuisance provisions. And so we would, from the PCAA point of view, strongly resist any watering down or reduction in the amounts, and in fact would submit that the amounts being put forward, are, if they were measured against other civil nuisance claims, are utterly inadequate and fall completely short of that which would be normally accepted by courts in other circumstances.
So can I make some points on behalf of the council?
Absolutely.
But the council's perspective is somewhat different from my learned friends. The council seeks to ensure that those who would be substantially affected by noise have access to funding for noise mitigation, so that they are no longer significantly affected by noise associated with the development. The £200,000 limit, as I explored in probably too much detail yesterday, results in, if you just look at the nighttime contour cap, it takes about 6.8 years for those affected to actually get all the houses to get mitigation. So by introducing a cap, and the fund is drawn on not just from those within the nighttime contours, but also the daytime ones too. So in effect, it would take longer than 6.8 years. You limit the ability for people to get the mitigation they need before the impact arises. People have to wait potentially as long as 7 or 8 years with impacts at night, because also the substantial change in the noise regime is one that arises at night here. And they suffer those impacts at night, and they have to suffer them for years before the airport then provides them with noise mitigation. So that's the concern, and I'm heartened to hear my learned friend saying that Bristol Airport Limited will consider lifting that limit. But the other issues are, of course, ones of principle. The contour areas that are covered at night, the only one that's covered is the 55 dB 8-hour soul level, as identified by BAL. Of course, Mr. Fumicelli said a lower soul level was appropriate. Yeah. There's no assistance provided to people suffering noise at night between the low and soul level whatsoever. And we say that approach isn't in accordance with national policy. It also doesn't begin to address the 3,000 odd houses that we've seen would experience the N60 level, 100 to 199 events at night, and which, once you take into account that LA Max S and LA Max F point, is above the WHO guideline level for sleep disturbance. Mr. Williams explained only a proportion of those N60 properties would fall within the sole contour. So that's a significant concern. The other aspect here is that Clause 2.3.4 identifies the mitigation level that the noise mitigation schemes are intended to achieve. But there's no evidence that the individual limits for each noise band will actually cover the works necessary to achieve the noise reduction in the objective in 2.3.4. And so we're extremely concerned. Indeed, we are convinced that the scheme as currently formulated is wholly inadequate and would be insufficient to provide the mitigation that many thousands of people potentially need as a result of the proposed development.
I mean, the way that I'm looking at it, we've got two slightly different aspects, haven't we? The cap of 200,000 per annum, which may or may not stay. I mean, that's a sort of financial cap. It may be that you don't hit that, it may be that you do, but that's something. It sounds as though, I'm just speaking off the top of my head here, but it sounds as though that was introduced for a particular reason, and I can understand that BAL would like a figure in their own accounts so that they know what they're liable for. But it may be, from what we're hearing, that £200,000 per annum as an issue may go away. But then, Mr. Taylor, you've then gone on below that to the actual scheme itself. And the way, again, that I was reading it, going through this document and the side notes, again, it seems to me that's going to be something that's probably not going to be agreed with the best will in the world.
The points I've just made are all points that we've been making during negotiations, and they're points we'll put in the note when we provide it to you next week.
Yeah, and I mean both from the council and PCAA, and indeed a number of independent witnesses, residents, we've heard about that. I think that's something we're just going to have to deal with.
Yes, I think so. You know, there's obviously a fundamental difference between the parties on the noise effects of the scheme and, and the changes. In a sense, you know, there's no point rehearsing that in front of you. I can assure you that the scheme that is being proposed is one of the most generous of any airport in the country. Most airports do not have schemes that go this far, and but in a sense that, you know, that doesn't get away from what Mr. Taylor would characterise as the sort of fundamental difference between us. Whatever the scheme is, that look, there are a large number of people that will not have significant impacts from the scheme. So I think, sir, as I say, you know, we've obviously discussed it. We do think very hard about the things that the council say to us, and you know, on instructions, I am telling you that if, as is clearly the case, the council don't want that limit, then we will, financial limit, we will take that out. Yeah.
Which leaves the other points, which are a matter of difference.
Leads to the other points, which are matters of difference on the evidence, and that will come into the closing, I assume.
Okay.
And sorry, so I think the ball is still on my side of the table, isn't it? I think then we've got to the end of that schedule, which is then, I think, the end of the unilateral. You will clearly have seen I've passed over other comments, and I'm more than happy for anyone else to pick up particular things. I've tried to focus on what I've understood to be some of the kind of principal drafting and other issues.
You've certainly picked up on all the ones that I've highlighted. There was one thing, though, because as you say, we get to the end of the unilateral where there would then be a plan.
Yes.
There isn't at the moment, that's fine, but somewhere or other above that there was the query which I thought I would be able to understand if I'd had the plan. So I'm just trying to look for it at the moment.
Oh, is this the airport and the application side issues?
Yes.
Yeah, that one's in hand.
Okay.
Yeah, well, I'm not sure we've seen the plans that are going to be appended, but we are promised them, and I hope that will resolve it.
That was fine. Just as one went through it didn't make any sense without.
No, well, if I can explain it very briefly. I thought Mr. Humphreys might have the answer. He doesn't know. The airport is described as a subset of the application side, so a smaller area. That gives rise to us for concerns about where do you draw those two areas. for the purposes of enforcement, particularly as there is a scenario there's more prevalent in the case of the EU. There's a scenario where the airport will be doing the highways works and they'll have step-in rights, and we need to just resolve that. I think it's capable of resolution, but hopefully that explains why you've seen us say, what about the application site? Why have you put the airport? What about the application? That's the issue.
That was it. Okay, thank you.
Nothing else?
Yes, I think that last point, thank you for clarifying that. This is an issue that we're trying to resolve, and I think there is also going to be a separate to all this land agreement of whether we carry out the works and the provisions and triggers and what we do, or whether the council carries out the highway works, and that's, I think, what we're trying to grapple with to make sure that works.
That's certainly linked.
Yeah,
certainly linked.
thank you.
Okay, right. I think we should call it a day there. Just looking forward to next week. We'll recommence on Tuesday, and then we'll hear closing statements from BALPA, Ms Sutherland, XR Elders and PCAA. Do we want to just point out there's going to be a deadline on Monday evening for any further evidence? We need to sort of say anything about that?
I think we've covered it.
We don't want bits coming in next week, do we? I'm not sure we formally sort of said.
I don't think we have, but we've set deadlines for a couple of things, but we haven't said nothing else. I think if anything else does come, so we turn it away and worry about it then. I've got one other thing to raise there.
You don't want me to say no?
Okay. That's the one I want to raise. Thank you.
Okay, well that's all from me. Mr. Ware.
Yeah, just one thing, which we just need to resolve. If you cast your mind back, there are two statements of common ground, the one in general principles and the one, a more detailed one, that we got in back in the dark ages somewhere. It's been a very unusual inquiry, because my experience has been that the SOCGs are referred to much more often than they have been. In fact, I wouldn't put any money on it, but I'm not sure if anybody's ever referred to them in this inquiry. But there we are. The only point about the statements of common ground is they're both marked as draft. And just for the record, and I hope this isn't an onerous exercise, but we ought to have the final version. Now, I hope that's probably only a matter of crossing out the word draft. But one ought to have a look, and when I say one, I mean you, ought to have a look, and we will as well actually, but we ought to have a look to make sure that as the evidence has progressed, there aren't any matters in those statements of common ground that actually clash with the evidence that we've heard. I doubt that there are. Did you think there were? Oh, I missed that.
Yes, I definitely referred to one of them anyway. I can't remember when.
I retract my comment completely then. It is literally only for the record, because I mean the vast majority of the material in those two statements of common ground are still going to be exactly as they were at the time. It's just that as one gets through to the latter part of the SOCGs, there may be matters that have changed. And I'm certainly not suggesting that there's a major exercise undertaken, but we do at some point need the final version. And if that means certain things are struck out because the evidence has continued, I'm not then suggesting that you recast the SOCGs to allow for the evidence, much more simply strike things out if they've been superseded.
Okay.
But I thought I'd mention that as another little bit of homework for some time or other. Okay, we're there. Okay, yeah, as Mr. Young said, Tuesday at 9:30.
Thank you, sir.